over to Hannah to talk to us a little bit about voter suppression and how we got here.
Hi, everybody. My name is Hannah Klain, and I'm from the Brennan Center. I'm thrilled to be here today. Happy to join you all to talk a little bit about the moment we're in now, why it's so critical to be having these conversations and the work that can be done. So I'm going to share my screen. A few slides to go through. Great. Okay. So voter suppression in America. The big picture question is, how did we get here? You know, we're in a critical moment in the fight for voting rights, and it's important to know how we got here. When we're thinking about how we got here, it's really most important to start with the Voting Rights Act of 1965. This was, you know, a banner piece of federal legislation, a banner piece of civil rights legislation that ensured that state and local governments could not deny American citizens the equal right to vote based on their race, their color, their membership in a minority language group. And it enshrined the right of every citizen to an equal opportunity to participate in our democracy. It outlawed literacy tests and other similar devices that had been in place to inhibit generally minority voters from being able to cast ballots. It outlawed discriminatory laws and practices, and perhaps kind of most critically for where we are right now, it had two provisions, Section 4 and Section 5, that established a pre-clearance system under which states and localities had to pre-clear certain changes they were making to their voting laws with either the Department of Justice, the Federal Department of Justice, or a three-judge panel in DC. And the purpose of this pre-clearance, we call it a regime, but it really is just a system. The purpose of the pre-clearance system was to ensure that states and localities had non-biased, non-discriminatory justifications for any changes they were making to voting laws in order to protect voters who had been sort of traditionally excluded from the franchise. It meant that states and localities that were going to change their laws had to take a significant amount of time and resources to present to the Justice Department or this three-judge panel all the ways in which their changes to the laws were not discriminatory and weren't going to have a discriminatory impact on various populations. So the kind of system itself was detailed in Section 5 of the law, and then Section 4 of the law, which was known as the coverage formula, determined which states and localities had to pre-clear their changes based on sort of a formula about you know, the particular place's history of race-based voter discrimination. So if you had been a longstanding discriminator, then you often wound up under the pre-clearance formula, meaning that you had to pre-clear your voting law changes. So for nearly 50 years, Section 4 and 5 assured that voting changes in states that you commonly hear about today, like Arizona, Georgia, Mississippi, South Carolina, Texas, Virginia, the laws in those states were transparent, that they were vetted, and that they were fair to all voters, regardless of their race. Then in 2013, the Supreme Court issued a decision called Shelby County v. Holder, in which they ruled that the coverage formula in the Voting Rights Act was unconstitutional. Basically, they gutted the most effective piece of civil rights legislation in American history by determining that that coverage formula was sort of out of date and it wasn't reliant on current data, and therefore it had to be struck down, which then rendered Section 5, the pre-clearance system, inoperable because there were no states to be covered by pre-clearance. We saw immediately sweeping changes to voting laws across the country. Texas, within 24 hours of this decision, passed a strict voter ID law, and you know, things have carried on since. But I want to flash forward to 2020 because I think it encapsulates the kind of fight of the intervening years, which was the fight to protect voting rights and the fight on the other side of that ledger to restrict voting rights. So as I don't have to tell any of you here, we had a historic and highly unusual election in 2020. On the positive side of things, we saw 35 states and Washington, D.C. make substantive changes to voting during the pandemic that made voting more accessible. So we saw a lot of changes to vote by mail, including significantly expanding who could vote by mail, affirmatively providing mail ballots, applications for ballots, providing postage for returning those ballots, returning notary requirements. And we also saw changes to in-person voting, including expanding early voting hours, adding additional days of early voting, things like that, which was all a very positive step forward, and frankly, a positive advancement and expansion of the right to vote in the face of what we had seen between sort of 2013 and 2020, which was an increasingly aggressive effort to restrict access to the ballot box through voter ID laws and voter purges, limiting access to voter registration, limiting access to early voting. We saw a real kind of pushback against that in 2020 as a response to the pandemic. But that's not all we saw. We also saw a tremendous amount of litigation fighting in the courts over the right to vote. We saw as many as 165 lawsuits get filed to protect voting rights, which is fantastic, though also signifies a pretty substantial need to take action to protect the right to vote. Of those 165 lawsuits, about 108 had pro-voter outcomes. So again, a very positive step. I will note, that the lower courts were generally more friendly than the mid-level courts, the courts of appeals. And frankly, the Supreme Court was pretty unfriendly to voting rights plaintiffs and cases. So obviously, as we look towards the future, that's something to sort of bear in mind that, the courts aren't really going to be the saving ground in the fight for voting rights. It's really about the state sort of legislative changes and what the rules are on the books in the various states. But I would say the other thing we saw, besides a lot of pro-voter lawsuits, were a lot of anti-voter lawsuits. As many as 77 lawsuits were filed to restrict voting access in 2020. So, the fight to vote and the right to vote was a really live controversy in 2020. And it played out, again, both in the states in terms of the laws and the rules they had on the books, but also in the courts. So where are we now as a result of what happened in 2020? Well, I wish I had better, happier news to deliver, but I think I have a really important, I'd like to think I have a really important kind of red flag to wave in terms of where we're at in the fight for voting rights. We are at a critical inflection point in that fight. And frankly, we are fighting a massive onslaught of laws to restrict voting access. So we've seen 361 bills be introduced just since January 2021, between January and March 24th, that restrict voting access. The Brennan Center tracks every single one of these bills. And so we can affirmatively say that between January 1st and March 24th, lawmakers in 47 states introduced at least 361 bills that would cut back on things like voting by mail, early voting, that would make voter registration and staying on the rolls more difficult. And these laws are aimed at deterring all voters from casting their ballots, but particularly aimed at Black and Brown voters across the country, which is obviously deeply discouraging and concerning, given this country's history of excluding minority voters from the franchise. Where are we seeing the laws? Well, as I said, we're seeing them in 47 states. So we're seeing them everywhere, is the reality. And I know that you all come to this conference from a broad swath of the country. And I think it's really important for everyone here to know that unless you live in one of the 3 lucky states that hasn't introduced at least one bill to restrict voting access, you likely live in a state where right now the right to vote is under attack. Where your legislature is introducing bills to restrict your voting access, to restrict your patients' voting access, to restrict your clients' voting access. That is happening pretty much all across the country. I have a map here of the states where those bills are actually moving, meaning they've had a committee hearing or they've passed in one chamber. that generally is a signal that they might ultimately pass. That number is also tremendous. So I think we've seen at least 55 bills already move as of March 24th. So unfortunately, what we saw in 2020, we can't really rest on those laurels. We can't really just assume that the franchise is going to stay protected, that the franchise is going to stay expanded. If anything, we're seeing a massive pushback to the expansion of the franchise in 2020, and that's part of how we have gotten where we are today. I will say the states that you've probably heard about, and the states, frankly, that I mentioned just a few minutes ago, as previously being covered under preclearance, are some of the biggest offenders in terms of introducing the largest number of restrictive bills. That's states like Arizona. Many of you have heard about Georgia, Texas, Pennsylvania, New Hampshire. And then from a sort of substantive standpoint, these laws really focus on the areas where we saw a lot of expansion of the franchise in 2020. They focus on mail voting, adding excuses, adding a requirement that you have to have an excuse to vote by mail, making it more difficult to just physically procure a ballot, making it more difficult to complete your ballot. We've also seen a number of states introduce new voter ID laws or stricter voter ID laws. We've seen states limit access to voter registration, or if they have automatic or online voter registration, we've seen states introduce bills to roll that back so that people are no longer automatically registered or can no longer register online. And then we've seen bills to make it easier to remove voters from the rolls, what we call voter purges. And often those purges are done sort of sloppily and remove far too many voters from the rolls. So again, I would just say, you've probably heard about Georgia, you may have heard about Arizona and Texas, but this is not just a fight in those key battlegrounds. Obviously, it's a critical fight there, but it's a fight everywhere. We're seeing this across the country, even in traditionally progressive states like Washington, Oregon, New York. I mean, we're seeing these bills everywhere. And so it's really, really critical that we don't let up in the fight to protect the right to vote, because we're sort of at a tipping point here. And so I think where I want to finish is by talking a little bit about, the premise for these laws. Many of you are doctors, medical professionals here. I assume that we all feel strongly about how important it is to have data and data-based findings to back up the assertions that we make. And the wave of restrictive voter legislation that we're seeing is really fueled by what we call the big lie. The big lie is that false, very sticky, false premise that the 2020 election and that all elections in the US are riddled with widespread voter fraud, people either registering to vote twice or voting twice in person or by mail. And this myth, and frankly, it's racist, xenophobic, underlying animus, is at the core of what drove the insurrection at the Capitol on January 6th and what is driving this upsurge in anti-voter legislation. And that's deeply troubling and saddening, obviously, but I think perhaps the biggest and most concerning problem with the big lie is that it's simply not true and it's not supported by data. So in 2016, the Brennan Center commissioned a comprehensive report of that election cycle and found that there were about 30 incidences of suspected non-citizen voting that were referred for further investigation or prosecution out of 23.5 million votes tabulated. Justin Levitt, who's a prominent researcher who actually just joined the Biden administration as a special advisor on democracy issues, has put out a seminal paper in which he looked at every election from 2000 to 2014 and found just 31 credible instances of impersonation fraud out of more than 1 billion ballots cast. When it comes to the 2020 election, the nation's top intelligence and law enforcement agencies have confirmed that there's really no significant evidence of voter fraud in American elections and that the 2020 election was secure. So I think it's important for you to know and to take away two key things from my talk here. One, we can't let up in this fight. We all have to keep fighting because the expansions to the right to vote that we saw in 2020 are not guaranteed, as we learned from the Supreme Court decision in 2013 and the legislative backlash we're seeing now. And the second is that to the extent that you're hearing people talk about the need for these laws because of this issue of voter fraud, the data just doesn't support that that's necessary. The data just doesn't support that there is widespread voter fraud such that we need to significantly constrain access to the ballot box for many, many people and for predominantly voters of color who've often been locked out of the franchise to begin with. So I'm going to leave it there. Of course, my email address is here. If you have questions, feel free to contact me. It's been great to be here today, and thank you so much for having me.